Hi, everyone, and welcome to the SRHM podcast, which explores new research and emerging trends in the field of sexual and reproductive health and rights, with a focus on using rights-based knowledge for action.
Welcome to this episode of SRHM Conversations. I am Eszter Kismodi, Chief Executive of SRHM, and today we are discussing a landmark ruling from the High Court of Kenya on the National Reproductive Health Policy 2022-2032, a case that brought together KELIN youth activists and women's rights defenders to challenge what they saw as a discriminatory and exclusionary anti-constitutional policy. With me are two experts at the heart of this effort, Maleche, Executive Director of KELIN Kenya, and Jerop Limo, Executive Director of the Ambassador for Youth and Adolescent Reproductive Health Program, AYARHEP, an organization working to advance youth and adolescent sexual and reproductive health and rights. Welcome, Allan and Jerop, in this episode.
Thank you for having us, Eszter. We are happy to be here.
So I would like to dive in first that what was this case really about? Could you, Allan, start explaining what this case challenged?
Thank you, Eszter. And once again, thank you for giving us a chance to have a conversation about this important case. The case, which we refer to as Petition 27 of 2022, which means it was filed in the year 2022 as the 27th petition at the High Court of Kenya, challenged Kenya's National Reproductive Health Policy that is running from 2022 to 2032. So together with a number of petitioners, AYARHEP, who the Executive Director Jerop is here, an activist Rachel Mwikali and Eszter Oko, and KELIN, we asked the High Court to examine whether the policy truly served all Kenyans, especially women, adolescents, and people living with HIV. We argued in that case that while the policy aimed to guide reproductive health delivery for the next decade, it did so in ways that excluded or discriminated against key groups. It limited adolescents' access to sexual reproductive health services by imposing parental consent barriers. It ignored the needs of those between 18 to 21-year-old women and added a clause requiring health workers to consider the health of the unborn child when making abortion decisions, something that is not provided for in our constitution. And so beyond the technicalities, this case mattered because policy shapes who gets care and who doesn't, especially in Kenya. And when youth and women's voices are absent from policy making, the result is a framework that protects systems and not people. And so we wanted to remind the government, particularly the Ministry of Health, that reproductive health policy must be anchored in rights, evidence, and inclusion, and not on morality or control. So, Eszter, that is what the case is about and why it mattered for us.
Thank you, Allan. And turning to you, Jerop, as someone representing young people and those living with HIV, and who is very vocal about the realities, the rights of young people and women and girls living with HIV and beyond sexual and reproductive health and rights. How do you see this case? Why was it so important to challenge this policy?
Thank you, Eszter. From a perspective of young people here in Kenya, first, a policy or a guideline, and this document in particular, plays a huge role in influencing the services we get to access, the services we are allowed to even walk into a healthcare facility and request for. And in this case, this document that goes up to 2030 would mean that there were services we could not access from the ages of 21 and below. There's still a huge concept around what can adolescents ask for in terms of reproductive health services and what are they not able to ask for. And for us as young people, it's to be able to challenge those ideas, those thoughts. And this is what this case meant. It gave us an opportunity to be able to say young people, adolescents have the ability to be able to access services and request for these services when they need them. It was an opportunity for us to say, you cannot say it is mandatory for HIV testing to happen for pregnant women. There's need for a basis for that. You cannot just force something onto someone else's throat. There was issues of abortion as well. There was issues of parental consent for minors, even without explaining what do you mean when you say a minor cannot access services and they need parental consent. What about mature minors? What about children who are already mothers? And in Kenya, we have young girls who are already wives. So there was so much that we were trying to also counter. But majorly for us is that this policy was truly not made by us. We didn't have an opportunity to fully contribute in coming up with the concept, with the clauses in the policy. And it was so sad to hear that it was said that we actually had an opportunity to contribute fully to this process. But for many of us, because I speak for so many young people who had an opportunity to participate in 2 or 3 meetings, that does not equate to comprehensively contributing towards a policy. And during this process, we saw some form of, we were in the room, but we were in the room for the sake of. And unfortunately, that was assumed that we got an opportunity to contribute to this policy. But the truth is we didn't have an opportunity to see our ideas in that document, to give our thoughts and to actually see them included. So for me, this case is an opportunity, one, for us to be able to ensure that policies actually reflect the lived realities of communities and of young people, which is quite unfortunate that it still doesn't. And two, it's to be able to see that the needs of young people are actually included in this policy, which is something, unfortunately, we did not see. But it is an opportunity to say we are willing to go to the extent of going to the court to say 1 or 2 and 3 aspects in this policy actually don't speak for us and they need to be changed. So that is what this case meant for us.
Thank you very much. This case is touching upon a huge public health and human rights concern that is globally recognized, and it is an issue, discriminatory policies in many countries around the world, adolescent and young people access to sexual and reproductive services without parental consent, mandatory testing and treatment, bodily autonomy and reproductive rights in relation to abortion. So turning to both of you, what did the High Court of Kenya decide, and how far this judgment move us toward justice and also upholding international, regional public health and human rights standards?
Thanks, Eszter. I will pick that up in terms of what did the court decide and how does this relate to national, international, and regional standards. I'd want to say that the court partially agreed with us. It declared unconstitutional the paragraph in the policy that was introducing the health of the unborn child into abortion decisions. That clause would have rolled back constitutional protections and also regional protections such as the Maputo Protocol by adding a new condition not found in our constitution under Article 26.4, which already limits abortion to cases where, in the opinion of a trained health professional, it's necessary to protect the life or health of the woman. So that was a significant affirmation, which communicated that the state, particularly the executive or the Ministry of Health, cannot sneak in extra hurdles that endanger women's lives. And this then allows us to continue to rely on our constitution and the regional instruments that we've signed, such as the Maputo Protocol and also the international instruments that speak to matters around reproductive health and safe abortion. However, the court upheld other contested parts, which means it did not agree with us and said that the HIV testing provision, the parental consent requirement, and the government's claim of adequate representation, they felt that the government had fairly made a good case around it. And one of the concerns when you read the judgment is that the court was saying, yes, though the Constitution says this and the policy says this, the Constitution still is supreme, and there's no way the policy could be read to mean that there's mandatory testing, which is something we remain concerned about because outrightly healthcare workers follow what's in the policy more than what's in the law. So for us, from a rights perspective, this is a mixed outcome. It's definitely a legal win for reproductive choice principles, but also a reminder that policy justice requires more than just courtroom victories because we have to get a conversation going around this. As KELIN, as part of the petitioners, we see it as a door opened, not the end of the journey, because it's clarifying that the Kenyan constitution remains the highest standard for reproductive health, and any policy or law must stay within the spirit. And the one other thing that the Kenyan constitution does is that it allows for any ratified international instruments, both regional and international, to be applicable in the context of Kenya. So what we've ratified with the Maputo Protocol, what we've ratified with the International Convention on Economic, Social, Economic Rights and Cultural Rights is all applicable in the context of Kenya by virtue of the Constitution. So I think for us, that's the biggest victory, and that is what the judgment means for us.
So as Allan, you explained, the legal victory really matters, but Jerop, how the policy still fails to address structural discrimination against women and girls, young people, and participation gaps, especially for youth, and how do you explain that it's not just a matter of judgment and it's not just a matter of policy, it's actually affecting young people's, women and girls, those who are living with HIV daily life. So how do you see the judgment, Jerop?
First, yes, it's a partial win, but I'd still say I hoped that it would be a complete win, because this is actually one of the first times actually we are truly going to court to say this policy is missing certain things and there are things that need to be adjusted. From a point of young people accessing services, like Allan mentioned, healthcare workers fully follow guidelines. That guideline is their Bible. So if the guideline says don't do this, they won't do that. It's not a matter of the Constitution, because for them, the guideline is what guides what they do and how they offer services. So the truth is, there are so many things that will be left out and that won't happen the way we had hoped for because of the guideline, which is already being implemented and being followed and being applauded in the country, while yet it still has a lot of gaps. Secondly, it's also a win for us because then it goes to show that young people, communities, civil society are willing to now go to the court to be able to challenge some of these guidelines and policies. For us, it's the opportunity to be able to sit with government and make sure it doesn't happen again, that no policies and guidelines are formed in our shadows and approved and launched while we were not involved and we didn't contribute towards that process. But it also gives us an opportunity to sit in rooms and challenge some of these biases. Because to be honest, we are still living in an era where policies and guidelines are being made by people's personal biases and cultural beliefs. And in the context of Kenya, religious beliefs as well. So when women want to practice bodily autonomy, when women want to make choices about their health, then why does someone else get to have the power to make that decision on our behalf? So for us, it's those two things. One, that we would have wished to have a complete win, but we take the partial win, and it provides us with some form of power that if you don't listen to us, we will meet at the gates of the courts. But secondly, is that there's some form of also opportunity for us to quickly get into rooms, because the government is like, if we don't involve communities, if we don't involve young people, if we don't listen to them, there are other offices that they can go to challenge us. While we are hoping to be able to continuously have engagements, even with healthcare providers, so that then they're able to truly be able to offer the services based on the guideline, but also based on the Constitution and based on our human rights. Even if the guideline says this, if I don't want to be tested for HIV, you cannot force it down my throat just because a guideline says. If I want to access abortion, you cannot deny me just because a guideline says. So there are so many things and there are so many wins we are looking at. But for us, most importantly, is to say we will not stop at this point, we will keep on challenging any guideline or policy that does not actually reflect the needs of young people and communities, for sure.
Thank you, Jerop. And I think it's not only letting down. I understand the victory part of the case, but this kind of unclarity of the judgment of upholding international and regional health and human rights standards and constitutional principles, it's not only leaving the young people and women and girls in an unclarified situation, but also the health service providers, whether they are the nurses or they are the doctors or community health workers, because actually UN and WHO guidelines are very clear about all these matters, whether it comes to parental counseling, the confidential access to services for adolescents, or on HIV guidelines. So what should they follow? What kind of guidelines? The WHO guidelines or the national guidelines that are unconstitutional and against the government's own commitment? So my question is that how to move from here? We need to celebrate the victory, what is big. On the other hand, there are next steps. What are the next steps? Allan, turning to you first in terms of legal steps, policy rechallenging and pursuing further policy reform, strategic advocacy. What is next from here?
Thank you, Eszter. And I think it's a very important question you ask us in terms of what is next. I think I want to begin by saying, and I've said this earlier, that the judgment has given us a very clear legal direction around the fact that you have to respect what the Constitution says and not go against what the Constitution says. And this is particularly on the aspect of including the issue of taking into account the health of the unborn child. And so from a legal standpoint, we have sat together with the lawyers that are involved in this to look at the decision and see the decisions we are not happy with around mandatory HIV testing, around issue of excluding young girls between 18 and 21 from screening from cervical cancer. Is there a possibility to challenge this before the Court of Appeal for them to be able to consider that? So that's one thing we are considering. And then on the aspect where we are happy with the outcome of the case around the aspect of not including the condition of taking into account the health of the unborn child, we want to engage with the Ministry of Health and the Office of the Attorney General to see what can be done for them to be able to align this. And we had the Kenya Obstetrics and Gynecologists Society joining the case as a friend or as an interested party. We hope to work closely with them to be able to see from a healthcare worker's perspective, how else can they also help influence this conversation at the government level and also to drive the conversation at the regional level. We definitely will not only be looking at litigation, we want to do a lot of conversations on policy reform and on accountability and monitoring. And so together with youth networks like AYARHEP and other coalitions we are in, we want to track how counties will interpret and implement the policy, because it's not been struck down, but the court has just said one part of it is not good. So we really need to be able to see what's going on there, and we're trying to see how we can work closely, get support to even develop scorecards and have community dialogues to check if any county is rolling this out, how that is going. And then the third thing we are trying to do is we want to see how we can leverage international frameworks that Kenya has obligations under, particularly CEDAW, the Maputo Protocol, our African Charter on the Rights and Welfare of the Child, all which affirm access to reproductive health as a fundamental right. So this judgment strengthens our advocacy at those levels, reminding the state that progressive jurisprudence must be matched by practice. And then finally, we are hoping to work with all partners at a regional, national level, including UNFPA, WHO, the African Commission on Human and Peoples, the African Union and other places, to ensure that Kenya's policy reforms draw from best practices in other countries. And we try to ensure that we are having SRHR youth-friendly services. And to the comment that you raised around which guidelines are to be followed, I think this is where we want to drive the conversation around harmonization and standardization of our guidelines, both at a national, county level, and aligning to what we have regionally and globally. But in short, this judgment is a starting point. Turning it into impact means legal follow-up, dialogue with government, dialogue with our partners globally and regionally, and having podcasts like this that allow us to communicate to people around what was this case about. Because at the end of the day, the right to health is only real when a young person in a rural clinic can access care without fear, stigma, or unnecessary barriers. And that's what we're hoping to achieve as KELIN alongside all the other petitioners. Thanks, Eszter.
Thank you, Allan. And as you are talking, it truly shows that it's not just a court case. It's a truly multidisciplinary, cross-sectorial collaboration between law and policy and service delivery and facing the lived realities and the discrimination that population groups are facing. Jerop, what are the next steps from your movement perspective, advocacy, and what your whole organization and your community stands for?
From our end, there are a few things. In this case, one is to ensure that there is no any other policy that brings out or has gaps like this particular one. And secondly, is to also ensure that we don't keep quiet about the gaps we have seen in this particular policy. I've been in so many engagements and conversation, and the reproductive policy still is already being quoted, is still talked about, and is being celebrated. While there are things to celebrate about, we also want to continue highlighting that there were gaps that were missed out and that we want to ensure that that doesn't make those issues forgotten. For us, it's truly very essential. Lastly, is to ensure that there's community and youth engagement in all processes. Like Allan mentioned, we want to be able to also monitor that young people are accessing these said services. Young people and women and girls have the opportunity to make informed choices about their health, about their bodies, that persons living with HIV have the opportunity to say, no, I do not want testing. No, I'm not okay with starting treatment now. And all those aspects. And that includes community engagement and dissemination and discussions and dialogues. We know the policy, we understand these technical aspects, but most of the people who will be affected by this policy don't understand what this means actually. And so for us to go out there and disseminate this policy and talk about the gaps and to even empower them so that in case they experience a form of limit, discrimination, or stigma, then they have the ability and the information to be able to challenge or ask questions or even demand for these services. So for us, it's those three particular things. One, talk about the gaps. Secondly, to disseminate the policy and to talk about it and to empower communities so that they're able to challenge in case they experience gaps while accessing services. And lastly, is to continue holding the government accountable, whether it is on implementation aspect, but also in future policy development processes. Yeah.
And what we always say about the policy, that the good thing about the policy that the government doesn't need to wait for a higher court judgment to change it and rectify shortcomings. So maybe the government doesn't need to wait to rectify the policy and engage in more conversations to overcome those barriers that have been pointed out through this court case. Thank you so much, Allan, Maleche and Jerop Limo, for this conversation. This podcast recording will be available on different various SRHM podcast and social media outlets, also on our blog. And we are looking forward to follow KELIN and AYARHEP websites as well and continue the conversations and hear from you about this case and the challenge of this policy. Congratulations for your partial victory and congratulations for your amazing and your partner's amazing work in this area. Thank you very much.
Thank you.
Thanks for joining us for this insightful conversation. Please check the show notes for a link to the SRHM journal, which is available online and open access. Follow us on social media and sign up for our newsletter to receive notifications for new publications. If you're enjoying this podcast, please subscribe, give us a rating, or leave a review. Sharing evidence-based and rights-grounded knowledge is our passion, and it's also critical to support the advocacy and actions that need to be taken to improve SRHR for all. We would very much appreciate it. Thank you for supporting the SRHM podcast, which is produced by our staff. The music was composed by Tiber Christian and Salomon Beautombe.